Hey guys, welcome to chapter 4, or week 4, chapter 8. We're looking at criminal law now. So, a lot of you have probably waited for this chapter. It's a really fun one. And we'll kind of jump right into it. I also wanted to check with you guys and see if you give me feedback. Just shoot me a message on Canvas. I can do these videos every week if they're helpful. So, let me know, one, if you think they're helpful. Two, I can also screenshot it where I'm in the slide too. So if you want to see my face, I don't know if that would make it easier, but some people like to see their instructor with the lecture. So shoot me a a Canvas message and let me know if you want me to do that. I can do that as well. Okay, jumping into cyber crimes. So we here in the US use a penal code system. So if a person is charged, they are presumed innocent until proven guilty. The burden of the proof is on the government, unlike civil law, where it is actually on the plaintiff to prove. This is on the government. Accused must be found guilty beyond a reasonable doubt, and the accused is provided all of the constitutional safeguards. A crime is defined as any act done by an individual in violation of those duties that he or she owes to society, and for which the breach of the law provides the wrongdoer shall make amends to the public. So what the heck does that mean? It means if you are charged and found guilty of any penal code violation, you will have a punishment. And it can be a monetary punishment, it can be incarceration, and we'll talk about those in a little bit. Parties to a criminal action. So we first have the plaintiff, which is the government. So the state of California, Stanislaus County, San Joaquin County, versus an individual. So Bob Smith, Susan Smith, whoever it is. The government is represented by a prosecutor, and the accused can be represented by either a defense attorney, a public defender, or themselves. We have 3 classes of crimes. Felonies are obviously the most serious, then misdemeanors and violations. Let's go back. So we're looking at, I don't know why this slide keeps getting messed up, but intent crimes, obviously you have to have had an intent to cause the crime. And you have to have what we call the mens rea and the actus rea. So you have to have the mental component and the physical component of the crime. Non-intent crimes impose criminal liability without intent. So this is something like reckless conduct or gross negligence, a vehicular manslaughter. Usually there's not an intent to cause injury, but you still cause damage, and so you're going to be found liable or guilty of that. Involuntary manslaughter is another one. These are funny. Let's go back again, and I'll kind of just explain through these. So I don't know why they're coming up this way. I think it's just the program. But the way it works is you're first going to get arrested. You're then going to be brought in to some sort of arraignment where they're going to read you your charges, and you're going to have the opportunity to obtain counsel. And then the indictment is when you are actually charged with the crimes that the DA is going to charge you with. A magistrate or a judge is going to read your indictment, and then you can plead either guilty, not guilty, or what we call nolo contendere. So nolo contendere is basically, I am going to take the punishment you give, but I'm not going to say that I'm innocent or guilty. Plea bargain then allows the accused to plead to a lesser crime. We see it a lot in criminal law. It saves money, it avoids trial, and it prevents further overcrowding of the jails. It doesn't mean that you are saying you're guilty. It just means you're taking whatever punishment they have agreed upon. If you do not take a plea bargain, then it's going to go to trial, and after trial, you're going to have a verdict. So you're either going to be found guilty or not guilty by a jury or by the judge, depending on what you choose. Different crimes we look at. Murder is defined as the unlawful killing of another with malice aforethought. And first-degree murder is premeditated and deliberate. So that means that you intended to kill a person and you actually planned to do it and carried it out. Robbery is the taking of a personal property by fear or force. If a weapon is used, it is considered armed or aggravated robbery. Burglary is the taking of personal property from another home, office, or commercial type building. So burglary and robbery are very similar, but remember, one is being done off the person, one is being done out of a home. Larceny is a lesser offense, and it is the taking of something basically that is not yours. So it can be done through trick or trade, but it has to be the taking of another's property without their, why am I blanking on the word? Without their knowledge. Receipt of stolen property is another one. So this means that you are accepting something that you potentially know is stolen. Forgery is what we look at when we say white-collar crimes. It's written documents fraudulently made or altered, change effects legal ability of another, and it's signing another person's signature without their knowledge with the intent to defraud. Embezzlement is very similar to forgery, but it's basically the fraudulent conversion of property that somebody entrusted to you. So we see embezzlement with accountants, with individuals that are maybe the beneficiary or the executor of a will. So they have the opportunity to get to the funds, but they're taking it and using it for their personal finances or personal growth. Bribery is offerer commits a crime where a bribe is offered. Offeree commits a crime when a bribe is accepted. Bribe can be anything of value. Compare this to extortion, where it's the threat to expose something unless money is given. So blackmail, basically, in other words. Criminal fraud is obtaining something through deceit or lies. So you tell someone you are, Bob Smith's mom, and you need them to give $10,000 for Bob Smith, and you are in fact not his mom. Money laundering is a term we hear very frequently, but it's basically hiding funds and running an illegal business through an otherwise safe-looking business. The Racketeering Act, or RICO, is a federal crime to acquire or maintain an interest in, use income from, or conduct or participate in the affairs of an enterprise through racketeering activity or through money laundering activity. Civil RICO just makes it a civil injury, and they can bring charges in a civil court. Criminal conspiracy. So this is a big one. If you watch Dateline, you see this basically every episode. 2 or more people in cahoots agree to go forward with a crime. It does require an overt act. So somebody has to actually take a step towards the crime. The crime does not have to be completed or committed to be held liable. In criminal conspiracy, the conspirators are held for whatever crime is committed. So if they conspire to commit a murder, just because one person didn't pull the trigger doesn't mean they won't be held liable. Computer fraud just restricts federal government information. I'm not going to spend too much on cyber crimes just because they follow along statutory regulations. Looking at Fourth Amendment, this protects against the right to overzealous investigation, and it provides reasonable searches and seizures by the government. Search warrants are based on probable cause, and they are necessary in most cases. There are very limited cases where they are not necessary. The government may not search businesses without a search warrant. The exclusionary rule provides that any evidence that's illegally obtained through an unlawful search and seizure is excluded and not used against an individual in trial. And you'll look at the case of Kentucky v. King and Arizona v. Gant. The Fifth Amendment states that no person shall be compelled in any criminal case to be a witness against themselves. So you'll hear people say, I assert my Fifth Amendment rights. It only protects natural people. It does not protect against businesses. And there is an attorney-client privilege where an attorney cannot testify against their client in a criminal proceeding if the client invokes the attorney-client privilege. Other privileges that are similar would be a doctor, psychiatrist, priest, spousal, or parent-child. There is no accountant-client privilege that has to do with Enron scandals and accounting issues. Immunities, you are immune from testifying again against yourself, and occasionally the government will offer immunities in exchange for testimony. Other constitutional provisions are the Sixth Amendment right to a public trial, and the Eighth Amendment protects against cruel and unusual punishment. It does not prohibit against capital punishment. That is a legislature issue, whether or not the legislature has deemed capital punishment to be unconstitutional, depending on the state you are in. Again, any questions? I apologize for some of those slides being screwed up, but let me know if you have any other questions and I will clarify.